Hi, I'm George Whipple, one-on-one with Paul DeCamp. Now, you were the head of the wage and hour division for George W. Bush. What the heck was that like? What was that job like?
Honestly, it was amazing. It was a real introduction to how the government works from the inside, going out on investigations with investigators, learning how to see the case through the eyes of the investigator, understanding what the government is looking for, understanding how matters come to the government in the first place. Typically, it's a worker or a group of workers that goes to a government agency and says, we've got a problem, we're not being treated correctly, whatever the issue may be. The investigator typically begins with a bias toward believing what the workers are saying. And I think having that perspective, being able to step back from the matter, of course, we're on the client side, first, last, and always, but being able to approach the case, to approach the situation and say, this is how your situation, your facts would look to somebody who is not on your side. And being able to bring that perspective so that you can calmly tell a client, look, it doesn't mean you're a bad person. It doesn't mean anybody did anything wrong or unethical, but there are technical issues here that to a third party could raise some risk or could be outright non-compliant, and we need to have a discussion about how to fix that.
What is the first thing that you do when a client comes to you and says, we think we may have a wage and hour issue here?
First, of course, is to get an understanding of what the issue is and figure out, is there a problem? How big is the problem? Is it a giant problem? Is it a relatively small problem? But then after that, it's helping the client understand what the options are. What are the different paths forward? Most of the time, there's a range of possibilities that will involve a mix of legal judgment about risk, but also quantification of the business risk and meshing those two to help the client come to the solution that is best for the client, which may vary from client to client. A lot of clients, at least before they deal with their first big wage and hour issue, approach these issues from the standpoint of, well, if we have a good argument for why what we're doing is okay, that's fine. If we think that it's being done in good faith, then that's fine, that's okay. If the workers seem happy with it, okay. But they're not thinking about it from the standpoint of the realistic risk that's presented, which is, does your situation present an attractive target to a plaintiff's lawyer or to an enforcement agency? Is there enough ambiguity, enough risk in your practice that it would invite someone who is interested in doing you harm to take a flyer on coming after you? That's how businesses really need to understand the risk they're facing. And the liabilities can be astronomical. Typically, it's the power of multiplication. If you have an issue and it affects hundreds or thousands of workers over the course of months or years, the numbers get really large really fast. And one thing that not a lot of people realize is even the U.S. Department of Labor has had multiple violations of the wage and hour laws. The wage and hour division, for the first 30-something years of its existence, misclassified its entire investigative force until there was an Office of Personnel Management desk audit that forced the agency to change their practice. The department itself had misapplied the administrative exemption, not through any bad intent, not through any lack of awareness of the law, but because the law is that ambiguous. And if the Department of Labor would essentially be a repeat violator under its own standards, that says a lot about how challenging these laws are for employers of goodwill to get everything right. And you've got to at least know what risks you're facing.
Now, on the non-governmental side, what have you learned in private practice that helps prepare you to advise clients on what civil suits might bring, how to prepare for those, how to mitigate those, how to maybe prevent those?
Having seen hundreds of disputes and having dealt with plaintiffs' lawyers from across the country, from various tiers of the market, from various styles, some who grew up as securities lawyers, some who spent their whole career as wage and hour lawyers, and some who were personal injury lawyers, coming to understand that what the plaintiffs' lawyers really, for the most part, feel they need in order to invest in a case is a case that's good enough to get past a motion to dismiss. That's oftentimes enough to cause them to invest in it because they understand, oftentimes a lot better than the businesses understand, that a lawsuit right out of the gate involves some level of settlement value. And businesses don't like to spend money on cases if they can avoid it. And they understand the tremendous pressure that a lawsuit, especially a class action lawsuit, puts on a business to resolve the case. And that gives them leverage right out of the gate.
We're in the post-Chevron era now, and you argued one of the most important appellate cases after Loper Bright. Where are we now? And what did that case mean? And where are we going in this area?
Well, Loper Bright put us into an entirely different world. For 40 years, we had a legal regime where courts were essentially required to defer to agency interpretations of statute, except in the most extreme circumstances. Now we have a different interpretive prism that the courts are using that put a lot more focus on the court's role at the outset in determining what a statute means and whether an agency has acted within the authority conferred by statute. That doesn't mean that every regulation is going to get overturned or that most regulations will get overturned, but it does mean that a lot of cases that challengers to regulations would have lost in previous years now become ones that are winnable. We challenged a Department of Labor regulation involving tipped employment. The court concluded that the department did not have the authority to take the action that it had taken, action that had been upheld by other courts in the Chevron era. So it is, in our case, a true game changer.
Well, thank you, Paul, and thank you for spending time with us on this one-on-one. I'm George Whipple.